All right. Hey, how y'all doing? My name is Chris. This is Bama Law, and I am so I can get it out of the way at the beginning. For one, I'm using a new microphone. So please leave a comment if it's bad, if the audio's I just need comments because there's too many settings, and I know that if I get really close, I'm sure it's going to be really noisy. So I'll stay back. I've performed enough in rock bands when I was a teenager to know the closer you get, obviously the louder it gets. But anyway, I thought today we would Lori Daybell. That's Arizona v. Lori Daybell. She is on trial for I don't know a whole hell of a lot about the case. I do know it's for a homicide, and I think it's of a child. So she has decided, much to the dismay, I'm sure, of most lawyers, to represent herself. She has decided to suffer. She's decided to suffer. She's gonna get run over, and it's inevitable that she's gonna. Oh, I didn't have good representation. They wouldn't let me. She's gonna inevitably bring up some just total bullshit reason for an appeal. She asked for it. I mean, look, man, you're entitled to it. You can't force an attorney on someone. That's not how we do our system. So, whilst it was, obviously you want a lawyer, you don't have to. You can do it yourself. So let's see how her hearing went. This will be my first time watching it, so I'm watching it with you live, or not live, but first time. Let me set the speed playback so we can get it past the censors or YouTube's, whatever. All right. Oh, wonderful. It's only on the left side channel. Oh, here we go. There's where it starts.
All right, this is State of Arizona versus Lori Daybell,
CR it's only on the left channel, so I'm sorry.
001704, CR 2022, 001242.
Attorney on behalf of the state, for the record, the next of kin in the 2021 and the victim in the 2022 are appearing virtually. Good morning, Your Honor. Pamela Hicks, advisory counsel on behalf of Ms. Daybell, and Robert Abernathy is out of office today.
Okay, what she even though Ms. Daybell is being her own lawyer, she's subject to the same rules as any lawyer, same for candor to the court, rules of criminal procedure, rules of evidence, which is where she's going to get hung up bad. Procedure can be, I'm not going to say you can learn it fast. You can in jail when you got nothing to do. It's rules of evidence is going to hang her up. She's got to know what to do. I mean, she's got to do it, man. She's got to do everything a lawyer would do. She's got to act as a lawyer. She is a lawyer for this case, period. So she has a lady helping her that's been assigned to the, I'm sure, she's been assigned to her by the court to act as a counsel to her, saying, hey, maybe you shouldn't do this, that. Daybell can tell her to go F herself. It doesn't matter. I've had clients that have done that. Just thought, hey, I can represent myself. It'd be great. And you try to give them counsel, and they tell you to pound sand. So it'll be interesting to see what happens. My guess is, if I had to bet money, at some point, Miss Daybell's going to say, uncle, and this lady will become the attorney. Let's see what happens.
You want to announce?
Lori Daybell, on behalf of myself.
All right, we have a number of things to get through this morning. The first thing I want to address is there's been multiple media requests. I don't know if there's a representative of the media that can address this, but my question is...
They're just dealing with now with the perfunctory stuff of the cameras.
If there's a single pool camera, is there some sort of agreement or cooperation between other media outlets to use a single camera?
Your Honor, if I may, Matthew Kelly, I represent Court TV, and our understanding is that, yes, there is a pool arrangement, and Court TV has asked to be the pool for the trials in this matter. I believe that that request is pending with the PIO. Regardless, the media that are interested in camera coverage do have a pool arrangement.
Okay. I know that there was, I don't know if it was Court TV or another outlet requested multiple cameras and a still camera. I'm inclined to just
Be
allow a
nice if they
single
actually had
camera. Do you
stereo
want to speak to
instead of
that?
just one left
Yes,
channel.
Your Honor. Court TV would prefer to have two of its own cameras. One of its own cameras is perfectly fine. Court TV's equipment is actually smaller than the camera we have here today.
Let's get to the
We
meat.
want to make sure that the cameras aren't going to be zooming in.
Require that all media receiving the feed delay it by
Just so you know, she's gonna be there's no jury, so it doesn't matter how they bring her in, what she looks like. She probably don't smell too great unless she's bathed, which they tend to not do. Hopefully, she brushed her damn teeth. They do that. They don't do that either. I don't know why. Convicts will definitely not treat you well if you do that. She should be shackled. My guess is she's going to be leg shackled, waist chained, and handcuffed. I doubt she's a threat or security risk. Like they probably could have gotten rid of the handcuffs, but
however long you wish to delay it.
And the camera, the pool camera would be simultaneously distributing that feed to whatever media requested.
That's correct. We have the capability to distribute to up to 30 or 40 different media outlets, so we have plenty of bandwidth to do so.
All right. Thank you.
Thank you.
they need to mute their mic.
All right. Let's get down to business on some of the.
Your Honor,
Yeah.
could I just add that we want to make sure that the cameras aren't going to be zooming in at any level to get to our notes and the things that are going to be on the table. I also previously, what has happened before is that they just have the camera on my face the entire trial. So I think when the judge is speaking, the judge needs to be on camera. When the
That's
state is
fair.
speaking, they need to be on camera. If we can add that to the order, I think.
All
it
right.
would
Well,
be
my draft
correct.
already includes that there'll be no zooming in on counsel table, anything on counsel table, or anything being handled, notes or that sort of thing being handled by any of the parties or the attorneys.
That's fair.
As far as what they focus on, they'll be limited to focusing.
We
on
don't
the
have this issue in Alabama because, as far as I know, we've never had a trial broadcast. Yeah, I mean that's just judges just don't do that. They might have, a news reporter in there with a camera taking a snapshot or something, but that's about it.
parties, myself, the witness, depending on the witness. I need to ask the state about that in a second, but they won't be allowed to broadcast any image of any juror. While I'm on that subject, let me ask the state: are you seeking any sort of protective order when a named victim testifies?
Not at this time, Your Honor.
Will you let me know if that changes?
Yes, I will.
Do you have do you have the names of your designated victim?
Protective order is just to protect. See, they've zoomed in. She's like shackled. I figured. Protective orders can be a variety of things. They're just there to do like what you would think, protect something. It might be someone's identity. It might be to protect against records being exposed or used in an improper manner, of that sort.
Or victim representatives that might be testifying?
Kay Woodcock is a statutory legal victim and will be testifying.
Is that the only one?
At this time, yes.
Okay.
For this trial, I should say.
For this trial? Okay. Let me ask this: are the parties ready to proceed around March 31st to April 1st?
Yes. Yes, Your Honor.
All right. Let me ask the state next. Earlier during these proceedings and past hearings, you indicated you thought the state's case in chief would take 2 weeks. You requested yesterday to screen for 6 weeks.
Your Honor, I did say 2 to 3
6?
weeks.
Okay.
But I did say that while we had a defense attorney on and not Ms. Val herself. I am familiar with other pro per trials where generally the timelines are in excess of those with a defense attorney assigned. So in order to ensure that we aren't asking a jury later to stay longer than we pre-screen them, I believe it would be appropriate to screen them for 6 weeks.
So now that you're gearing up for trial and maybe you have a better idea, how long do you think your case in chief would take with a normal amount of costs? I know that's hard to estimate.
And again, I would say 2 to 3 weeks.
3 weeks?
That would be at the outset of it.
Okay.
Right now, the judge is just trying to get details in order as to time, how long it's going to take. He's trying to do what's called a scheduling order, so that he can say, "Hey, discovery better be done by." Let's see, what is this? This is March. He might say by June 1st. I'm just making up dates. Discovery better be done by June 1st. If it was a civil case, he can order mediation to be completed by August 1st. And a trial date set no later than September 15th, somewhere in there. It's not going to be like that for this because this is a criminal matter. So, but you're still going to have the judge is still going to be doing a scheduling order.
Probably, yeah, 2 to 3 weeks.
Okay. Let me ask the advisory council, if we do an questionnaire, would you be assisting Ms. Daybell with your laptop in going through the answers that are received?
Yes, Your Honor. I mean, assuming we do all of that, because a lot of times the courts send us back to our office to go through that. So if we do that here, then yes, of course, she's welcome to use our laptops.
Right. My plan is we can do jury selection in the South Court Tower 5C. I know that the state has requested that the entire trial be held there. We can't do it. We can do jury selection there. I can give you rooms here for your victims and witnesses as need be that are outside this courtroom that we can have them stream in if you want, depending on, I guess, who the witness is or who's back there.
And obviously, Your Honor, I don't know if the public will be attending this or not. This also is a little different in that even in the mornings, the jury is going to be potentially out here while the court is having morning calendar. If there's media out there as well, I'm just trying to protect the integrity of the trial by ensuring that the public, the media, are not interacting with witnesses at any time while they're out there. It's difficult when it's a very small hallway and very limited rooms to put them in. Obviously, I need a room for the victims that's separate from any witnesses.
They're wanting to discuss about.
Well, we have on this floor 6 rooms, 5 or 6 rooms.
Getting the jury.
We have 3 right behind this courtroom, and we can utilize them as need be to ensure that there's no improper
sure wish they'd have
contact
a
between
stereo
media, the public in
feed and
general, and any
audio.
victims or witnesses. We can also ensure that the jurors don't have contact. If that means we bring them up in a separate elevator and have them assemble somewhere else, we can accomplish that. So my plan will be to do an questionnaire, remote questionnaire for the first 200 jurors. That questionnaire,
That's
I
a
need to
high
get a
jury
final
pool, usually about
joint pretrial
100.
statement with the list of
What we
witnesses
get,
to
maybe.
include the names of witnesses in that, but I'd like to send out a draft to everyone by the end of this week. Let me bring up my calendar. We'd probably send that out to the first 200 jurors around next Thursday, March 20th. Yeah. Oh, I guess they can't send it out. Okay, so we can send out that the 24th to the 27th, meaning it would be cut off on the 27th. The answers to those questionnaires would be emailed to the parties. That would give the parties the 28th, 29th, 30th, and 31st to go through those answers. We would meet on the morning of the 1st, discuss who needs to be let go based on those answers. Also on the morning of the 1st, a number of walk-in jurors that for whatever reason don't fill out the questionnaire in advance would come in to the jury room, the jury assembly room that morning and fill out the questionnaire. So that morning we'd also deal with those walk-in answers as best we can. Oh, that's right. I back up. The initial answers for the remote, we're going to meet on the 31st. Let those people go. Whoever we don't let go will be told to report on the afternoon of the 1st. On the afternoon of the 1st, we'll be dealing with the walk-ins that come in the morning of the 1st and the people that we haven't let go the afternoon of the 1st. That will be in person voir dire as needed. If we need to, which I anticipate we probably will, we'll do another 200 jurors on the 2nd.
Oh my God.
And if need be, we have another 100 jurors on the 3rd.
That next set of 200, that wouldn't be a remote question?
They don't have a capability to do it remote. So we may have to, what'll happen is on the 1st, all those people, after they give their answers, will be randomized. The list will be re-randomized. As we proceed through the 2nd, those people get added onto the bottom of the list. So as soon as we get 12 jurors that qualify, that everyone's happy with, that don't have issues, plus probably 3 or 4 alternates. So as soon as we get to about 15 or 16, we're pretty much done with jury selection. So we don't have to necessarily question all 200 of those people. We can do panels of 20 or something like that. I anticipate losing quite a large number of people just based on prior media coverage and people already having some sort of opinion about the case. I normally wouldn't include a defendant's name in the questionnaire that goes out remotely, but on this case, I'm inclined to, just because that's what we want to know. We want to know if people have heard about the defendant and whether or not they've heard about, or if they formed an opinion about her
My
or this
guess
case.
is the answer is going to be yes.
Does anyone have an issue with that, State?
No, Your Honor, I think that's a good idea. That's going to be at least one of the initial reasons to strike a lot of jurors.
My only issue with it, Your Honor, is that it could be bad both ways, right? If you put the name in there, if you don't put the name in there, it's been my experience that people will say they haven't heard when they know who that really is, and there's people that will want to be on this jury just for this purpose.
Well,
Still has to be
all the research indicates that these questionnaires, people are more likely to give honest, candid answers than if they're.
That's horse shit. It doesn't matter. What matters is it cuts out a lot of your strikes. You don't have to waste a strike saying, "Hey, does anybody know Miss Daybell or know about it?" It cuts it out. You don't have to deal with it.
In a group of people and they feel sort of that peer pressure of what's a good answer and what's a bad answer, your name's going to come up sooner or later. So I would prefer to just get it out in front of the potential jurors to begin with. My e-questionnaire is going to be fairly basic. It's going to focus on qualifications, the charges, the witnesses, and then obviously whether they have an opinion about you or this case. For the people that make it past that level, we'll question them more thoroughly in person.
And like you were saying, as far as group kind of voir dire, in my experience, we went through 1,900 jurors in my last trial, so it would be good to do individual voir dire if we can, than group voir dire, because they learn things just in the voir dire, and it disqualifies a lot of jurors.
I'm not opposed to that, but that's going to be sort of a day of play it by ear sort of situation, whether we do small panels or just go a single person. If we go single person, our jury selection could extend into the next week. But if we're able to seat a jury, I would expect opening statements on April 7th, somewhere around there. Does the state indicated, I have it, there was just one day in April that you wanted to go a half day?
Correct, Your Honor, the 24th.
Huh.
Right. When can you file some sort of pretrial statement that sets forth all your potential?
All right. Looks like, just for those of you that are like me and have no idea, I went ahead and looked it up. And ChatGPT says, yes, she has already been tried and convicted once, May of 2023. She was found guilty of the first-degree murders of her two children, Tylee Ryan and Joshua Vallow, as well as conspiracy to commit first-degree murder and the death of Tammy Daybell, her husband's prior wife. She was sentenced to life imprisonment. She scheduled to stand trial again, where she faces charge of conspiring to murder her fourth husband, Charles Vallow. Yeah, she has nothing to lose, nothing. So yeah, I don't know why. I guess she's bored. Sometimes they get bored and they just want to do stuff.
Witnesses and a statement of the facts.
Probably by Thursday.
All right. Does the state anticipate any presentation of autopsy photos or crime scene photos? In other words, I'm trying to gauge. I would usually put in a question about jurors may be required to view evidence that shows wounds or that sort of thing. Is there anyone that's unwilling to look at this type of evidence?
Yes, Your Honor. We will have both, obviously, the self-defense trajectory and those injuries are very relevant.
Okay, so I will include a question about that type of evidence. Sometimes jurors don't want to look at that type of evidence. So, all right. Any questions or concerns
they're
about?
going to have to look at that. I mean, that's part of being a jury. You're going to see the evidence. So my guess is they're going to show the evidence of her other convictions or other murders to show pattern and practice, that like a Ted Bundy type rule where, you're trying to show that, look, I mean, we're just trying to convict him for one murder, but he's done 29 others, or somebody has done 29 others. We suspect it's him because it's done the exact same way, same MO, same signature, et cetera, et cetera. So that's my guess.
Election, the proposed trial dates from the state.
No, Your Honor.
Just so I have it clear, Your Honor, we're going to start on the 31st with jury selection. Is that
We'll
correct?
be meeting on the 31st,
Okay.
And then actual dealing with in-person jurors on the 1st, 2nd, 3rd.
Yeah, Brooklyn. That's if you're talking about in the jumpsuit. That's Lori Daybell. Yeah.
Okay.
Let me ask advisory council. Are there any dates that advisory council would need to be dark?
I am fine for April. I didn't hear back from Robert. I would think.
Please let us know, because in that e-questionnaire, I'm going to put in a proposed schedule. I don't know that I'm going to screen for a full 6 weeks based on the state's anticipated presentation, maybe 5 weeks. So into let us know the schedule into the first week or two of May.
As soon as I get an answer from him, I'll email your judicial assistant.
All right.
Again, he's just setting the timeline. It's just scheduling orders. It's what it seems like this hearing is going to be about. Kind of glad you skipped too much.
And one more time, Your Honor, so the remote question is going out on March 24th. All answers have to be back by the 27th, so we will get them on the 27th.
You'll either get them late the 27th or first thing the 27th.
I don't know how they're going to do these electronic questions. I mean, do they expect everybody to check their bloody email? They already, you're supposed to get notice that, hey, you've won the jackpot. You're now a juror. And you've got to be at the courthouse on this day, this time, and please report, blah, 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 blah. I don't know what happens when you get the email if you haven't gotten notice. I guess that's what he was referring to with people walking in that hadn't done it. It's just peculiar. It's just COVID hangover crap. I mean, they should just send the paperwork out and be done with it, or just spend enough time, do it that day.
Okay.
Oh, okay.
Okay.
You should get them some point on the 27th.
Just so we can plan, because it sounds like we'll just go out to Estrella and go through these.
They're closing it at 8 again on this one.
You'll have to have a internet connection.
Yeah, we can use our laptops out there.
Okay.
Because you want to be ready to discuss everything on March 31st.
Yeah, and if the parties have an obvious, there's some jurors that are going to be obvious that need to be let go. If you're ready for that, that's always helpful. I know it's a little bit more difficult with pro per defendant and consulting like that. All right, let me get to.
They ain't cutting their mics. I can hear them.
All right, the defendant had filed two separate motions for specific discovery. The first dealt with communication between the assigned deputy county attorney and law enforcement agencies. I've read and the second one was, well, let's deal with the first one. I've read the response from the state. Basically, your response is you have disclosed all those communications. There are no other communications.
Correct, Your Honor.
All right. So let me ask the defendant.
Yeah, we received 6 email communications, and they were in a short time frame, not the full time frame. And it seems to me that in the last email ends in kind of a question that was probably answered, and then there's like no more communication. So it doesn't make sense that there's no more. We asked for all of them if they could be provided to us. We don't understand why they're not being provided to us, and what the state is possibly hiding at this point, and they can't just turn it over so that we can go through them. It's been long over a month.
They haven't entitled it as a motion to compel, but I'm guessing they've got a motion to compel for discovery on the table
Since we filed that motion. So we would just like them to please turn over whatever they have left.
All right, and I'll ask the deputy county attorney. I imagine some communications are by phone. So in other words, we're not captured.
Correct, Your Honor.
All right. Based on the state's avowal, I don't know. I can't tell them to turn over something they say they don't have. So I'll find that the state, based on their avowal and officers of the court.
And that's right. He can't. I mean, he doesn't know. There'd be no way of knowing unless he goes into their computers. He's not going to go and do that. It's just not going to happen. So a lot of the times, these type of motions, I mean, you're entitled to all of the discovery that would not inculpate you, but exculpate you, and tend to prove that you're innocent. And if they don't have it, they don't have it. Hopefully that's something that, if they do have and they've lied, that later on it'll come out. It sucks, but this is life. For any trial, this is life. You have to take them at their word that, hey, dude, we've done everything. Maybe the text wasn't followed up. Maybe it was followed up with a phone call. There's no way to do that.
Complied with the request. The second one is a little more, I wanted to get clarification on. That was defendant's request for video interviews, but it seemed like based on the state's response that there was some confusion about what was a interview recorded in an interrogation room situation versus a body cam. Did the state's response provide clarification to you?
No. So the body cams were turned over, and they're in like 12-minute increments. There's like 4 different body cams. This was a full 2-hour video that was released by Gilbert Police to the public, and it's online. So I would like that video of the interrogation room, the full 2-hour one, to be turned over to the defense.
All right. So do you know what that is?
Your Honor, based upon the defendant's reply, she's requesting a video interview from the 31st. Those are on body cam and were turned over to the defense. We have requested everything from.
Then the key terminology is this is a Brady material, Brady v. Maryland. I'm not sure if it was in the 60s or the 70s, one of the two. Basically, Brady is summed up. It's fairly simple. Give me my shit. I mean, it's pretty blunt and vulgar, but it's if you have good relationship with the prosecutor, that may be what you call him and say, give me my shit. I want my evidence. Okay, well, we'll send it over. Okay, great. Hopefully you get it in the next, 2 weeks? Yep. Okay, wonderful. Thank you. That's how your relationship should work. It should not be so adversarial that you have to fight. And but I mean, she has nothing else to lose. She's an inmate. I mean, she's already sentenced. She ain't getting out. You know, she's gonna be suffering for a while.
From, I think that one was from actually the Gilbert Police Department. A lot of these overlap. So I am not sure what the defendant is.
Who was the person being interviewed? And you said the 2-hour interrogation that Gilbert released.
So it's myself and my daughter, Tylee Ryan, and Melanie Gibb.
And is that in an interrogation type room?
Yeah, it was at the Gilbert Police Station, and I didn't realize we were being filmed that whole time. I didn't know we were being filmed, but we were being filmed in that room.
And are you familiar with a video in a room?
Yes, that's what we have disclosed. Is an interview of, it is
And you're saying you don't have,
defendant, her daughter, and another.
and you're saying you haven't gotten that?
They have given 4 about 12-minute body cam videos of the policemen's body cams that were in the room with us, and they go in and out of the room at different times. So there's different body cams. They're all mixed up. It's not the full entire one. And the full entire, my understanding is that the full entire 2-hour interrogation room video from the ceiling is available online, but I don't have it in Discovery.
That's what I'm trying to
You would be
clarify. So
entitled.
did the state disclose not a body cam, but an interrogation from up in the corner of a room vantage point?
I mean, we disclosed a lot. Let me see if I can find out. We did. Yes, my paralegal is present here as well, and she has advised that we did. Your Honor, we disclosed over.
Can your
Where is
paralegal
it?
provide a Bates number or something so that maybe the defense just
Okay, a Bates number is not every court uses it, but a Bates number, it's used mostly in federal court. I'm kind of surprised they're using it in state, but it provides a tracking mechanism at the bottom corner of a page. It'll have a not necessarily just a number, but it'll have for each document, so that you can go back and go through. Okay, well, it's Bates stamp J111, and everybody can go find J111. So it is helpful, but I mean, we don't really use it in Alabama courts, or at least not the ones I practiced in.
is overlooked it?
Let's see if we can find
Practice, I
the
should say.
actual
Maybe the Discovery notice.
discovery letter.
Okay.
They finally figured out to cut the damn mic. That's what I hate about those. I freaking hate those things. Because I'll sit there and run my damn mouth the whole time talking, crap with a client. Let me see if I can get rid of this background. It's jittering it out. Wait, what's
Your Honor, all we do have is the 4 body cam. We
Oh,
can
there we go.
ask again and see if they have a overall.
Are you getting this? Have you seen this, or someone told you that there's this video?
My mitigator showed me part of that video. Yes, with my previous team. That's how I know about it. Otherwise, I wouldn't know about it. And she said, "Do you know this is online?" I didn't have any idea.
And you're sure it's the Gilbert PD on that date?
Correct.
All right, I'll ask the state to follow up with Gilbert on that.
We will, Your Honor.
There, if that is out there, obviously it should have been disclosed. All right, remind me to follow up on that next time we are together. Next, I have a motion in limine, 2 motions in limine, one regarding Alex Cox statements and one regarding Tylee Ryan's statements. All right, so let me ask the defendant. Generally, any hearsay is defined as any out-of-court statement offered for the truth of the matter asserted. The state is referencing what are definitely out-of-court statements. Obviously, there's some exceptions to the hearsay rule, and there are other things that are characterized as non-hearsay. So how do you think, let's first talk about Alex Cox. How do you think the statements fit into either one of those exceptions or non-hearsay?
I feel like the state is blanketing that whole thing, and obviously it's like a case-by-case basis, right, on these statements. So there is the police interview of Alex Cox that I did not think falls under hearsay.
Why not?
Why does it not fall under hearsay?
Yeah.
Because we're not using it for the truth of the matter asserted. We're using it in corroboration of the circumstances. Everyone came in and told their same story that corroborates different facts in there, not for the whole truth of the matter.
Aren't you arguing that what he said was true?
I can't say whether another person says that it's true or not, but I'm saying what he said and what my daughter said and what I said in those 3 police interviews determined what the police said, how the police acted, what they did after that, their next steps, how they treated the entire case like it was self-defense. All of those are relevant to the defense that it was self-defense. So yes, I think they're for that purpose. But I also think that Alex's statements also have a lot of the exceptions apply. 803, 804. There's a lot of exceptions that also apply to some of his statements and not all of his statements.
Such as what? Which statements do you think they apply
So
to?
specifically his statements made on body cam to police in the driveway, specifically his.
I don't know what the statements are, so that's what I'm asking. What specific statements do you think are allowed to come in under the rules of evidence?
I think under 803.1, the present sense impression is his statements made to police officers at the house.
A present sense impression is where you're actually observing something and you're talking about it as you see it happen. So isn't he saying, again, I don't know what the statements are, but is he saying what happened prior? Or is he saying
Yes,
something
prior.
okay.
Correct.
So it's not a
Prior.
present sense impression.
Okay.
What else?
Then I think it falls under 803.2, excited utterance. He was under the stress of the whole situation. When he made those statements.
What was his demeanor when he made those statements?
Upset.
What's the specific statement?
I shot my brother-in-law in self-defense. I got hit in the head with a bat. There was an altercation. I don't know what all the statements are, but
How long after the incident did he make these statements?
immediately after, as far as I know.
Well, immediately to some people it means 2 seconds, to other people it means 30 minutes. Tell me what immediately means to you.
As soon as the police arrived.
I don't know what, did they arrive 30 minutes after the incident? 10 minutes, an hour?
I was not there. I do not know what time they were. Right.
All right. Let me, so you're asserting excited utterance, some of these statements come in. What else?
803.3, the mental, emotional, and physical condition, because it shows his state of mind, which was scared at the time.
Any others?
Yes. 803.5b, the recorded recollection. I know that in the state's reply to my response, they did not think that 805 applied. Because A, B, and C, but I did not see an and after A. So my assumption was that B and C, since there's an and after B, were what needed to be put together. So B was made or adopted by this witness when the matter was fresh in the witness's memory and accurately reflects the witness's knowledge. So I felt like 803.5b, the recorded recollection of his police interview and the body cam footage applies under that exception.
All right. Generally 803.5 is a recorded recollection, meaning it's something they wrote down, or maybe they recorded their voice saying something. Let me ask the state to respond. We're just talking about the Alex Cox statements.
Your Honor,
Maybe I should start with,
Yeah.
does the state intend on introducing any statements from Alex Cox?
Your Honor, I haven't decided if we will at this point. I can say with 100% certainty, we will not be admitting his interview by police that was done at after 10 o'clock in the morning. We don't,
Are you referencing what time he was interviewed versus the time of the incident?
let me say it this way. So the state has laid out in its motion the timeline. So that is actually in our motion. We show that when
8:30 a.m.
is when
roughly.
the 911 call was made. So we have soon after that, the police arrived and there's body cam video from that interview. Then Alex Cox is later brought to the police station and there is a in-depth interview with detectives at a little after 10 o'clock in the morning.
So you may or may not be attempting to introduce statements at or around the time that the police responded.
Correct, Your Honor. If we do, those would be brought in as co-conspirator statements against a party interest. So obviously the state can bring in statements that are hearsay against a party.
Right. But I guess, is the state intending on introducing any statements of Tylee?
No, Your Honor. Kylie made no statements at the scene other than giving her general biographical information on body cam. Her entire statements were made at the police station, again, after 10 in the morning.
All right. So on your response as it relates to Tylee, you say, again, present sense impression. I don't think it's a present sense impression. You also argue excited utterance. What else?
8033, which is mental, emotional, and physical condition, but the same thing, her state of mind, then being scared. And also 8043, statement against interest. They use that statement in the indictment where Tylee says that Charles says, if you hit me with that bat, you're going to jail. That's the part where she's nervous in her interview saying she's scared to tell the police that she's the one that brought apply to Tylee's
All right.
police interview.
All right. Anything else the state want to be heard further on that?
Your Honor, the only further thing I think that the state will bring in is that obviously the defendant has been found guilty of killing both Tylee, other individuals, but in this case, the defendant cannot benefit from killing a witness and then later try to bring in their statements for their benefit. So in addition to none of her statements being admissible under the rules of evidence, as any of the exceptions that the defendant has done, we also believe that it would be improper for her to be allowed to bring them in under that theory.
In other words, there's been a judicial finding that the reason Tylee's unavailable as a witness is because of the defendant's actions.
Correct, Your Honor. There has been a jury trial and she has been convicted of that.
All right. All right. The court is on a preliminary basis precluding references to Tylee Ryan's statements, any statement made by Tylee Ryan. If there's some reason where a door might be open to any of those statements coming in, the defendant's requested to make a request outside the presence of the jury regarding that, and we'll deal with that outside the presence of the jury. On Alex Cox, I think that's probably going to be more of a statement by statement basis, but I'm skeptical of any statements coming in hours after the initial police response. I think we'll deal with what statements may or may not come in when the police first arrived on scene and or the 911 at the time that they're attempted to be introduced. All right. I also received yesterday state's notice of disclosure and request for disclosure. Did you get a copy of that?
No.
You haven't seen that yet?
No.
I'm sorry, the
State's notice of disclosure and request for disclosure. I didn't realize it was actually filed in January, so you should have seen that. I misspoke when I said I got it yesterday. It was filed January 16th. Have you seen that?
I'm looking it up. What are we? Dates
I think the court may have ruled on that one, Your Honor.
Lori.
Well, I don't think I ruled on, at the very end, you're requesting she submit to fingerprints, palm print, footprint.
What?
Oh, that's okay. I think that was fired, yes, significantly. So
You want her DNA
that
too?
would be to tie her to any of her.
Is that for other conviction purposes?
Correct, yes.
Oh boy.
All right. And when did you want to do that?
If we are going to be here on the 18th, we can take them then.
I don't know that we need to be here on the 18th.
Don't you already?
And obviously, I
have
was
them?
unaware we were going to set this because we set it
Right.
just recently. So I don't know if we can keep that on just to take that.
Okay, what about the state, you requested copies of any recorded statements made during interviews conducted outside of your presence. Is there any of those, were there any interviews conducted by you or your team? Were there any interviews conducted of any witnesses out by you or your team that you're aware of?
So far, not that I'm aware of.
No problem, Darcy. How can you tell me how my mic is? It's brand new, and I don't know if it's worth a damn or not. Y'all could just tell me. It's good to have you.
All right.
By the
Do
way,
you plan on-
this trial is going to be a damn dumpster fire. So just imagine a dumpster on fire from, I don't know, some terrorist or BLM pushing it down the damn street, and it's on fire. That's her trial. It's just going to be going down the street. Come on, play.
on calling any experts to testify?
We do plan on calling one expert.
Who's that? Has it been disclosed to the state?
We are, yes, we're working on that today as an addendum to the
Who's that?
witness list that, Lonnie
Good,
Dworkin.
thank you.
Lonnie Dworkin?
All right. That's your
Had to play with
investigator?
the game.
No, my investigator, Jeff White.
Oh, what-
That's the expert.
What kind of expert is Lonnie Dworkin?
Phone and digital.
I think I remember his name. Are you aware of that?
No, Your Honor.
All right. Expert reports and
The state not only has to disclose stuff to her, she's got to disclose it to them. Like, what witnesses am I calling? Am I calling expert witnesses? If I have expert witnesses, what's their credentials? Who am I calling? Not necessarily when I'm going to call them, but who am I going to call? What's their credentials, etc. That way, the state can at least, or if it's a civil case, the opposing counsel or party, they can challenge it. They have every right to do that. So
disclosures are due 30 days before trial generally under the rules. So
now that's here's what pisses me off about that. Alabama's great. Damn it, we're good. It's like 90 days out. You're going to get your evidence. You're going to have trouble. You're going to get a continuance. If it's like 30, 60 days out, they're going to continue it. Judge is going to be pissed. Georgia, in the YSL trials, 10 freaking damn days. All evidence. They have to give you 10 damn days. How in the hell are you supposed to do a damn criminal trial with damn 10 days of preparation for your evidence from the state? You can't. It just befuddles it just boggles me.
if you're planning on using that witness, you need to get that disclosed right away. And I may have to take that up depending on what the state's position is. But at this point, it's technically late.
Maybe another reason to be here on the 18th. Obviously, if that's disclosed this week, we can
You
potentially
can let
address
it
that
in.
issue on the 18th.
It's not a big deal.
All right. Let me ask the defendant, do you have a position on the taking of prints and photographs? Generally, identification type things are permitted over any defendant objection. So do you have a record you want to make on that?
Not really.
All right. I don't see any
For
reason
what
why
purpose? I don't understand.
in the event that you're convicted, it may be used to prove other convictions. That reminds me, is the state planning on proceeding in the second trial, regardless of what happens in the first trial?
I believe so, yes, Your Honor.
And how much time would you need between the conclusion of the first trial and the start of the second trial?
Your Honor, I would say at least 30 days since we do need to actually subpoena out-of-state witnesses for the second trial.
I'm wondering if it wouldn't benefit everyone to go ahead and set that a provisional second trial date now.
That's on, Your Honor.
This is what court's like. A lot of boring time.
May 11th is my last day.
Is that second trial,
Cut
how
your
long do you
damn
think it
microphone.
would take the state to
Probably
present?
about 3 weeks as well.
Similar?
Look at all the legal notepads. That's all she's got in the damn jail. They get that, and they get this little stubby pencil. Sometimes they're even like a rubber pencil. I don't know if you've ever seen one where it's literally made out of freaking rubber. You can't do anything with it. I don't know how they write, but a lot of this stuff, almost all of their stuff is going to be hand prepared. I mean, I don't know of anybody getting a typewriter.
Your Honor, I'd like to remind the court that the last day is May 11th.
And he can extend it.
Well, I'll probably exclude some time based on the fact that you can't do two trials at once.
There you go.
The state could combine the trials and do two trials at once, but they don't want to do two trials at once. So it really violates my
Correct.
speedy trial rights if they do not give me a.
No, because it's too goddamn confusing. They don't want to do two trials at once. The judge doesn't have to do that. He does not have to consolidate it. No, he does not. It does not. It does not in any way screw with your Eighth Amendment rights. It doesn't.
A speedy trial by May 11th for both cases.
Excuse me, sir. I guess Sixth Amendment.
Not to mention that they did combine all the discovery into one case. They didn't give me two different.
Funny
separate
too, in Alabama, if you can say that all damn day you want, you're gonna be suffering because you ain't getting nothing. You ain't getting no damn speedy trial if you don't raise that at district court at preliminary hearing. Your first damn time in court, you have to go. Yeah, I want a speedy trial. Yeah, I need a motion filed, and you file it. You do that, you're protected. You ain't gonna get your evidence like you want, but especially if you try to have a prelim hearing. Alabama is unique in that if you don't raise it at your preliminary hearing in district court, which if you have a felony, you would try it in circuit court. Same is true in district. If you have a misdemeanor, if you're trying in district, you still have to raise it. If you don't, you'll lose it. I mean, I had cases that they languished. Damn, they took them 2 years to indict someone. And they might go to trial in another 4 years before it went to trial.
discoveries for two different cases, which would be much more convenient considering the voluminous amount of discovery that they piled onto us.
Does the state want to do combine both cases?
Your Honor, if the court gave us a little time to work it out and the defendant wants to join them, I mean, obviously,
I don't know that
the normal defense attorney, and I don't mean that in any way, normally they would be severed.
severed because you don't want one jury to know about the other
Correct.
two separate charges and have a harmful rub-off effect of
Right.
one
They're trying to protect
the evidence in one case affecting the evidence in another case.
Correct, Your Honor. That's why they were filed separately. But if the defendant wants them together, the state would have to request this be pushed back slightly so that we could then get all the witnesses for that trial together, since they were not subpoenaed for this trial. But if that's what the defendant wants to join them, and she understands that
I'll do it.
prejudice, and that she's then going to be waiving that prejudice with that, then the
That's
state is
true.
certainly willing to do that. But we would then have to request to have that
She
trial.
might as
for this
well
trial to
bend
move back.
over right now and just get prepared. She does this, she's an idiot. So there's 2 trials that they're looking at doing, and not just the one. So I only knew of this one, conspiracy. But remember, conspiracy takes 2 or more people, so I don't know who her conspirator is.
That's not what I was saying, is to combine them. I'm just saying, give me my second trial by May 11th. So the court can figure that out.
What?
All right, well, I'm going to waive some time on that second trial over the defendant's objection. Primarily, again, the defendant can't try both cases at the same time. Secondly, I'm not sure how much actual prejudice there is with a time.
And another thing is, to do the trials together, there has to be a nexus. There has to be a connection between them. Okay, it's got to be out of usually the same transaction and occurrence. It cannot just be because I got busted with dope on September the 1st and then got out on bond and then got nailed with a gun 20 days later. And well, it's the same dude, we'll just try them together. That's not the same transaction and occurrence. If, for whatever reason, I got busted with the gun at the same time as the dope, and for whatever reason, they split the charges, they wanted to do 2 different trials. What the hell for? Might as well just do one together. Just have both indictments go.
Violation in the sense that you wouldn't be released from custody anyway. And thirdly, the rule for time violations under Rule 8, I think it's 8.6 is that any violation should be a dismissal without prejudice unless there's an actual prejudice shown, in which case the state could just refile the charge.
Right.
Regardless, I think some time is warranted to be excluded because primarily you can't try 2 cases at once. What if we set a start date for May 12th?
Maybe they have a weird state rule in Arizona that they don't like trying them together. I don't know.
I realize that's could potentially be a quick turnaround, but again, I don't think this case is going to take 6 weeks.
Your Honor,
We can adjust that as necessary.
I, again, am going to ask for a longer time. I believe this will,
Yeah, Darcy, I didn't know that either.
and to have the state try to get those witnesses lined up and subpoenaed while in trial, I don't believe it is.
Well, if I push it out any further, the parties need to be aware that I won't be trying the case. I don't think I would anyway. I'm rotating at the end of June.
So his okay. Yeah, I get it. It depends on the area or court, whatever. He's probably on a circuit, and they have a different term. They call them terms, and so like Georgia does it, where they'll have a I think it's two terms a year. It might be 3. They'll have a break in between each one, and like term 1, he might be the trial judge, and then he might get rotated to another circuit or whatever if he's sharing another county. In Alabama, you've got Usually your larger counties will have its own district circuit court in each one and district attorney. However, the smaller ones will be sucked in and create a judicial circuit. So you might get a judge. Everybody might go, for instance, I practiced in Calhoun County. If everybody in Cleburne was on the Georgia line, they didn't have it. They had a district court. That was it. So if you went to circuit court, everybody went to Calhoun. He might be being sent to another county. It's probably next door, but he's saying he will not be there. So it'll be a different term. So that's why he's saying that. At first I thought maybe he got unelected, which is, I don't think it's that time of year. That would be like a January time.
And given some of the trainings I have to attend in June, I
6 weeks is retarded.
don't think we could get it done.
Both parties could send out subpoenas now for that second date for May 12th, correct?
What?
Well, that's assuming we're done by about May 1st, probably. In this case,
that's not going to
the first
work.
case.
Mm-hmm.
Yeah, she's typical of a pro se. This is typical.
And then, Your Honor, I did indicate that the state needs to be dark in May, the 21st, 22nd, and 23rd. You said 21, 22, 23, correct?
Of May.
And I would need to be dark the 19th, 20th, and 21st as well. So
But given that we would be dark that entire week anyways, it really doesn't make a whole lot of sense to.
all right, sorry to interrupt. Let me speak with the criminal presiding judge about scheduling the second trial. We can discuss it on the 18th.
Okay, so
Let's keep
presiding judge
the
makes
18th,
the
but
rules.
let's move it to later in the morning.
In a
Actually,
lot of places, especially in federal court, they'll have different local rules depending on where you're at. And they can be significant. And then you're like, wait, why is there a rule of criminal procedure or civil procedure if you're going to freaking change it on me? So why is there a freaking standardized book? Tennessee's bad about that. I've practiced there too. And they have local rules. And it's like in Alabama, we abolished them in, I think, 76 or 78. And the only ones that can be done is very basic. Like when they open and close, and any rule they want to do, that court has to submit it to the Alabama Supreme Court and has to be approved. So therefore, you go into every court. I can go in from Jefferson County, which is Birmingham, to all the way to Mobile. It's the same thing. So I hate local rules. They're stupid. I don't understand them. I just don't get it.
all we're going to do is discuss a couple of matters, and then there's no reason for the fingerprinting and stuff to be broadcast or on video. So I'll prohibit that from being
That'd be
recorded
awesome.
or otherwise broadcast. So have your person here. Let's do that at 8:15 a.m. on March 18th. And then we'll also discuss whether the defense is disclosing Lonnie Dworkin as a witness and whether or not he has a expert report prepared and disclosed at that time. I will have the questionnaire for you by then, so you can review it. Anything else we need to discuss that I've forgotten about from the state's perspective?
Your Honor, I showed two other motions that the defense filed that I did not see rulings on by the court. They were both motions to dismiss. One of them only related
file
to 22
Denied.
I think. No, I'm sorry. Both of them related to both.
What's the filing date?
I
January 14th.
I'll tell you a funny story. I actually watched it in law school. That movie, My Cousin Vinny. Fred Gwynn plays the Alabama judge. Now, the way it works, where he comes in and becomes a lawyer or whatever and bullshits, that would never fly. But I have actually had a judge literally throw down a book and go, boom, here's the book of civil procedure. You better know it by Monday. It's like, well, I just passed the bar exam. I don't care. Better know it. But honestly, Fred Gwynn really plays a really good example of a judge, at least from where I'm from. Not necessarily a small area, just in general. It's interesting to watch out west. The judges become a lot more mechanical, like this guy. There's nothing wrong with him. He's just mechanical.
Was an 8.2 speedy trial one on February 4th, which was an extradition rule 8.3.
of February 4th. Okay, so the motion to dismiss CR 2022-001242 for lack of speedy trial, I ruled on January 24th.
Okay.
That minute entry was filed January 24th. And then the motion, was that the motion to dismiss CR 2021 and 001704 and the other for violation of Speedy Trial Act?
Correct.
That was ruled on February 25th. So last week,
Okay.
a week ago. Anything else from the state?
Pay attention to your motion,
Anything else from the
ruling.
defendant?
Yes, Your Honor, I have one kind of housekeeping matter that I wanted to ask you about. I know that MCSO has some security restraints, the things that I have to wear during trial, and
I meant to.
I wanted to ask about that as far as, am I going to be able to stand at the podium to talk to witnesses, to question my witnesses and to cross-examine, or am I going to be able to move about with the leg
Now, this
thing
is
and
a
the
good
shock
argument.
vest and all that?
This is what I have an issue with is, look, she's not a risk. I'm sorry. I mean, look at her. That doesn't mean that she can't cause a hell of a ruckus in a fight. That's not what I mean. If she were someone that I would really be worried about, I say, okay, put a shock vest on her, whatever, underneath her dress, clothes, whatever. Look, they let Ted Bundy walk around the whole courtroom for like, I don't know, 8 weeks in all of his trials. So, and acted as his own attorney. So she should be able to walk around freely. The jury should not be seeing handcuffs, period. End of story. They should not see any of that.
You're going to stick to your table and you can go to the podium. Okay. When you're giving your opening statement and closing argument, you'll stay by the podium.
Okay.
And if you need to hand a witness an exhibit, your advisory counsel will do that.
Okay. Or my paralegal can do that too.
Well, is your paralegal going to be present here designated as your?
Yeah, Darcy,
I
yeah.
guess they can be
It's going to
present.
test everyone's patience.
I prefer advisory counsel to be the one that approaches witnesses if you need to hand an exhibit or something like that.
Did she,
Okay, so I'm gonna be standing there, and if she's
wait, she just, did Lori Vallow, did she just say my paralegal will handle it? That lady's supposed to be an attorney. What the, she just demoted her own lawyer? Yeah, this chick next to me, she's just my paralegal. She ain't really a lawyer. And you know that lady sitting there going, oh, you suck. I am a lawyer. You gonna make me do all this paralegal crap?
she's sitting here, she's gonna come get something from me and go walk it over to the witness and then come back.
Correct.
Just the logistics of it. just
Yeah,
fine.
and there'll be a table or a cart here that'll have all the exhibits on it within reach of the podium. So
If she's actually a paralegal, holy freaking crap.
Okay.
anything else?
Your Honor, do you use case lines for exhibits?
No.
Thank you.
I think they're still working out the bugs on that. So
Do we need to have our exhibits in place?
all right, we'll see you at 8:15 on March 18. Be at recess on this now.
Yes, you're in the back.
Yep. They're done. That's it. All she wrote. That is typical pretrial hearing for a trial. Typical. It is over. That is it. Done. Kaput. It's in the can. So I don't know if you have any questions. I'm probably going to end the stream because it's over. Unless you have any other ideas, then maybe we can watch it. I don't know. I might do another one tonight. Another live stream to watch. I'm not real sure. I've done one on Bundy. He did several trials, and they're really good to see what a pro se trial can look like. His is weird because you can tell when he's going over the crime scene with the responding officers, he's getting off. He's getting off on it, and they have to reel him in. He does a good job as his own counsel. He obviously lost and was executed, rightfully so. But it may be something to watch. I think Carol Durant has them. I hope that she wouldn't mind us borrowing them. She is the only surviving victim of Ted Bundy. So if you could go look at her channel, it's her name is Carol Durant. It's CarolDaronch. She became a police officer after she went through all of it. So that may be something I do. I don't know. Dadgummit, I've done another hour. I can't get these under 30 minutes. I'm telling you, I just can't freaking do it. So anyway, I'm gonna cut it. Thanks for letting me know about the microphone. I don't know why my camera isn't getting me on my ugly face on here. It sucks. I'm using an iMac. Well, good. Thank you, Darcy. The camera's just not. Yeah, we're moving anyway. So instead of like everybody else, where I have like a YouTube shrine, everybody has a cool light and all that stuff. I have nothing. I mean, it's boxes everywhere, so it sucks. So I'm gonna keep streaming until we move. There'll be a little bit of a break, and then I'll pick it back up when I've moved, and that'll be in June, 1st of June. So we got plenty of time. So thanks y'all for being with me. This is Chris of Bama Law. We're out of here, and remember, if you ever wonder why you can't make it in the legal field or you have trouble, it's a club and you're not freaking in it. As George Carlin used to say. Y'all have a good day. Bye.